and welcome to the fifth installment of the Law Office of Melissa A. Days live broadcast program, On the Bench. My name is Brian Prince, and with me here today is the one who needs no introduction, Melissa Day herself. Before we get started on today's presentation, I need to address a few housekeeping topics. Initially, this is an invitation-only broadcast series designed for busy claims professionals looking for a quick and convenient way to keep on the very cutting edge of claims handling, but without sacrificing more than an hour of their busy days. Each presentation, including today's, will consist of 50 minutes of lecture followed by 10 minutes of open questions. In keeping with our high-tech infrastructure, this is a live streaming presentation, and as such, we ask you to hold your questions until the end. As always, we'll be recording today's presentation for future viewing by those who are unable to join us today, so we'll be muting all audio feed during the main segment of the presentation. We encourage you to submit your questions via the chat feature or hold them to the Q&A section at the conclusion. Today's case discussion is notice, the difference. Lastly, since this is an office full of legal professionals, it's our time for our legalese disclaimer. This presentation is being offered for informational purposes only. Any statements or analysis provided therein are not intended as legal advice, nor does this presentation constitute the creation of an attorney-client relationship, and past results do not guarantee future outcomes. Lastly, the names and identities have been changed to protect both the innocent and the guilty. Without further ado, Melissa Day.
Thanks, Brian. So today, as Brian told you, we're going to discuss notice, the difference. And what our emphasis is going to be on is what's the difference between a successful notice defense, or a claim where you successfully defend on notice, and a claim where you don't get a disallowance based on notice. So please, as you're watching today's presentation, make sure that you pay close attention to things where there might be a difference. Today's, we're going to cover, hopefully, the following practice points. The first thing that I'd like to talk with you about is the importance of documents in defending your claims. And the case study that we're looking at today will include the following kinds of documents in the defense of the matter. And that those are witness statements, prior medicals, the employer's procedures, and documents which reflected challenges to the claimant's credibility. The second practice pointer that I would like to discuss with you is preemptive prejudice. And lastly, the third practice pointer that we'll cover today is the difference. And it's a multi-pronged approach, which we believe will make the difference for you in prevailing on a notice defense. Thank you. And so let's start with the statutes. Section 18 of the Workers' Compensation Law contains the provisions requiring timely notice for a claimant to bring a claim. But rather than look at all this dizzying text, what I'd like to do is distill notice down to its essential criteria for you. Notice of a claim must be written. It must be provided within 30 days of the accident or death, if that unfortunate occurrence happens. It must be raised prior to the first hearing at which all parties are present, and all parties who are on notice are present, and before the claimant testifies. And pretty much our PH16 rules have abrogated any issue about whether or not notice is timely raised a defense. And lastly, it's important to know that late notice by a claimant can be excused. And the provisions of the statute which allow for the claimant to be excused from providing timely written notice are that notice for some sufficient reason could not be given, that the employer had actual knowledge of the injury or the accident, and that no prejudice to the employer resulted because of the late notice. Okay, so we're talking about notice, the difference. What I'd like to do is present our case to you as bare bone facts. So our case study has an accident date of October 17th of 2012. The C3, the claimant's claim form, was received by the board on December 5th of 2012. Arguably, that could be construed as the employer's first notice of the injury, because an employer can be charged with its carrier or TPA's knowledge of a claim, and generally you are charged with knowledge of documents once they're contained in e-case. The employer's actual notice wasn't received until December 13th of 2012, when several medical bills were forwarded to the employer for payment, and they referenced a work injury for this employee of the employer. Finally, the claimant alleged oral notice, but it was to a non-employer on-site supervisor on the date of accident. We'll discover here on our facts that our employer is a temporary agency and they placed the claimant at a general contractor. And the claimant alleged that he informed an employee of the general contractor on the date of accident. So based on those facts, we would win, right, Brian?
Oh.
Yeah, right. Slide. The bare bone defense that you would raise based on those facts is simply Code 5A, which is failure to report an accident timely under our new system of the Froy and Sroy 04 filings. And that is the notice or Section 18 defense. So what I'd like to do with you now is to show you the difference in the facts. And we're going to present this as story time. The story that we told the workers' compensation law judge in this claim, which I think you'll find has a lot more color in it than the bare bone facts that we just presented to you. Slide. Our characters in our story are as follows in the chart above. The employee or the claimant is named Mel Ingerer in our story, and as Brian told you, the names of both the innocent and the guilty have been changed. The employer or the temp agency is We Pick 'em, You Pay 'em. The contractor where the claimant or Mel was placed is known as customer. Our office manager for We Pick 'em, our client, the employer, his name is Joseph Mama, but all his friends call him Joe.
Was he so fat?
No fat mama jokes, please. The on-site supervisor for customer was Jack Tripper. The safety coordinator for customer was Sue Persave. And again, remember that customer was our client's client. And then lastly, we also have the account representative for our client, the employer, We Pick 'em, whose name is Seymour Sales. Once upon a time, excuse me, I have to turn to the right page. Once upon a time, there was an evil employee named Mel Ingerer. His employer, We Pick 'em, You Pay 'em, an attractive and industrious placement agency, hired Mel to perform construction work on September 11th of 2012. Very important date. Please make a note of it.
We won't forget it.
We Pick 'em finds skilled laborers for construction projects for bigger companies. Now, little did the unsuspecting We Pick 'em, You Pay 'em know, the wicked worker would allege that he sustained a work injury on October 17th of 2012, a scant month or so after he started working for We Pick 'em. Being a prudent employer as well as attractive, We Pick 'em had a well-documented orientation procedure consisting of a 21-step process, which included steps that an employee was supposed to take should they sustain an unfortunate work-related accident. And in addition, We Pick 'em required its employees, including Mel, to sign an acknowledgement that he understood and was aware of the procedures for what he should do should that unfortunate event occur. Despite being presented with his signature on his acknowledgement at trial, the duplicitous Mel Ingerer denied ever having gone through an orientation when he was hired and remembering that he signed an acknowledgement of the procedures that he was supposed to use to report an injury. The innocent employer generously placed the ungrateful and nefarious Mel Ingerer in a construction job with its client, Customer. Customer, a conscientious general contractor on a very large construction project, had medical personnel on the site, including an EMT, to provide emergency aid to an individual who might be injured on the job site.
That is generous.
It's conscientious as well, wouldn't you say?
I would.
Mel was not happy with the work he was assigned to do at Customer. Picture? He asked We Pick 'em whether there was any other work that he could do at Customer, and they inquired on his behalf, trying to make sure that he was happy. Customer also wanted to keep him happy and moved him 2 times in an effort to do so. Despite these efforts, Mel missed several days of work in between when he started working on September 11th of 2012 and the day that he ultimately stopped working at customer on October 18th of 2012. On October 17th of 2012, Mel worked from 7 o'clock in the morning until 4:30 p.m. At trial, under oath, after having sworn to tell the truth, Mel stated that he was in a trench, stood up very quickly, and hit his head on a pipe overhead. He was wearing his hard hat, but despite that claimed that he nearly lost consciousness. He also claimed that he stood up with such a great force that he hurt his neck. Mel claimed that he told customers on-site supervisor Jack Tripper that he hurt his neck and that he did not want to work in that trench anymore. Jack Tripper told Mel that he should find customer's safety coordinator, Sue Persave, to report that he'd been injured. And remember, they had an on-site EMT there who could have rendered aid to Mel. Instead of finding Sue, Mel became frustrated and left the premises without telling anybody on the date of the alleged accident. The next day, October 18th, Mel reported for work at customer's job site. He said he wanted to see if he could be put on light duty, despite the fact that he hadn't seen any doctor who told him that he couldn't work full duty. He also said that he wanted to go to the customer to report that he'd had a work injury the day before. While he was there on October 18th, Mel got into a shouting altercation with Jack Tripper, who then informed Mel that his services would no longer be needed at customer. Not surprising. On his way off the job site, Mel ran into customer's safety coordinator, Sue Persave, whom he'd been told the day before to mention his injury to. Despite having been told by customer that his services were no longer needed, and being aware that if he sustained an injury, he was supposed to report the injury to his employer, Weeb Hickam, Mel did not go to Weeb Hickam to report his injury on October 18, 2012, the day after the alleged accident. Additionally, although Mel had several conversations with employees at Weeb Hickam after the date of accident, about various things like his paycheck, he did not bring up a work injury. Additionally, Mel made numerous harassing phone calls to Sue Persave, and he left her hostile messages, but for some reason, again, did not mention a work injury. Unbeknownst to Weeb Hickam, Mel sought medical treatment at an emergency room on October 23rd of 2012. About how many days after the accident?
About 6.
Not even a week. He alleged that he had an injury at the base of his neck and informed the ER personnel of the alleged work accident on October 17th of 2012. It appeared that Mel may have been forthright about having had previous symptoms in his neck to the emergency room personnel because the previous complaints to the neck were mentioned in the emergency room records. However, the claimant, Mr. Mel, had treated at the very same emergency room, so perhaps they simply had access to their own records. Regardless, there were references to previous neck complaints in the emergency room records from 2006 and 2008, well before the incident, the unpleasantness, on October 17th. Incidentally, the emergency room records that were obtained may have also suggested, well, they really came right out and said that the emergency room personnel were suspicious that the claimant may have had some drug-seeking behaviors before our accident date. Although Mel was not told by a physician that he couldn't work, instead of returning to Weeb Hickam for additional work, because only customer said that they didn't want his services, Weeb Hickam would have been happy to place him back in another job. But instead of doing that, he hired an attorney. His attorney helped him complete the C3 form, which we know is a workers' compensation claim form, and that form contained a big fat prevarication on it. He asserted that he'd never had any similar injuries before this date of accident. On December 13th of 2012, Joseph Malma, office manager for WePick'em, was shocked when he received 3 medical bills for treatment provided to Mel from an alleged incident on October 17th of 2012. Joe knew nothing of any such incident, and so he immediately called Mel to ask him to come into the office to complete an incident report, as is the requirement according to the employee handbook for WePick'em. Joe also prepared a detailed statement regarding everything that he could remember about Mel and his employment at WePick'em and the injury that was allegedly sustained on October 17th. Seymour Sales, the account representative for WePick'em, who was responsible for overseeing WePick'em's employees at Customer, also prepared a statement. He prepared that statement as soon as he was aware that there had been a claim of an incident on October 17th of 2012, and he detailed everything he could remember about Mel's employment and some issues that he'd had before he stopped working for Customer. Mel did come into the office to complete an incident report for WePick'em You Pay Him, and at that time he was also given a referral to have a drug test performed. This again was standard procedure for this employer, as Mel acknowledged following his orientation.
Reasonable.
Shockingly, Mel did not go and get his drug test done.
I'm shocked.
Additionally, as had been the case with the claimant's C3 form, the claimant denied ever having a similar injury on the incident report that he completed for WePick'em. Sue Persuade, the safety coordinator for Customer, was advised that Mel was saying that he had an incident on October 17, 2012, his last full day of work at Customer, and she was asked to prepare a statement regarding the events that led up to that alleged incident date. That statement didn't include any information about an alleged injury because the claimant never said anything about an injury, but it did include information about the altercation that Mel and Jack had had on his last day at the employer. The client, the contractor, Customer. Additionally, Jack Tripper, the on-site supervisor for Customer, he also prepared a statement indicating that Mel never informed him that he had a work injury. WePick'em, being an employer consumed with justice and fairness for its largely honest and dedicated workforce, felt compelled to fight Mel's workers' compensation claim. And as a result, they hired yours truly to champion their cause. Good story?
Very. At least so far.
You're having some technical difficulties apparently with my sound, which is shocking to me. Slide. All right, so this is the story that we just told you. Is that better?
Yes.
Thanks, Najee. The story that we just told you is what we submit is the difference and why we prevailed on these facts. It was a colorful presentation to the judge, which not only had in it documents, which don't, what, Brian? Documents don't?
They don't lie.
Generally, they don't lie. Unless the document contains a lie, in which case it's generally easy to present as proof of a lie.
Or was changed after the fact.
True. So we have documents that we believe were ultimately part of how we were successful on this claim. We preemptively described prejudice, and we also provided the judge with a multi-pronged defense attack. So let's talk about the documents that we used in this case, which we think were an important part of what was the difference in helping us prevail. One of the first things that the employer was able to give us was their orientation and their employee handbook acknowledgement. This ultimately was helpful to us in attacking the claimant's credibility. He denied ever going through an orientation, and yet we had a piece of paper which had his signature on it, which he identified and agreed was his signature, indicating that he'd gone through an orientation. Additionally, it gave us good documentary proof that the claimant was aware of what the procedures were for reporting an injury. He was well aware that his employer was We Pick 'em, not Custom Er. So his protestations notwithstanding that he informed somebody at Custom Er about his injury, which was again belied by other testimony, he was obligated to inform somebody at We Pick 'em about his injury, and there was no evidence in this case that there was notice provided before December of 2012, nearly 2 months after the accident, alleged accident. The other document, what's that?
Incident.
The unpleasantness. We also produced the employee incident report in C3, which contained right on them misrepresentations, which because we got the prior medicals, we were able to prove were not true. That's where we were able to show that a document lied using other documents. Now, as Brian will likely agree, one of the reasons we wanted the prior medicals were because of the reference to previous neck injuries in the emergency room records. And certainly you want to unturn every stone when you're exploring possible defenses. And because there were previous treatment to the neck, we felt that it was important to obtain those previous medical records. Brian, how do you think we would have done if we tried to argue for apportionment on this claim?
I don't think apportionment would have been very successful, considering, based on my understanding of the file, the claimant was given a pre-employment physical, and he was fully capable of doing this very heavy-duty job. So based on that, I'm assuming most judges will just say that, well, the claimant was able to work, so you have no apportionment claim.
Right, and even if there wasn't that additional evidence, how many times have we seen claimants just come in and say, I was working full duty without restriction, and that's sufficient to bar on a legal basis any claim for apportionment to a prior non-compensable condition?
Too many.
Yeah, exactly. So although we weren't very optimistic that obtaining the prior medicals was ultimately going to provide us with evidence to refute causal relationship in this claim, we still would be loath to leave any stone unturned. And in fact, these medicals turned out to be quite interesting. The medicals not only ended up helping us to attack the claimant's credibility because of his refusal to just concede that he'd had previous treatment to the neck, we also discovered in these medicals the previous instances where the claimant had demonstrated very evident, strong drug-seeking behavior. Additionally, he was admitted to a hospital after a motor vehicle accident and needed to have a splenectomy, but he checked himself out against medical advice, was brought back to the same emergency room this following day, had to undergo emergency surgery to save his life, and then again checked himself out against medical advice after being caught in the bathroom smoking marijuana and removing his own PICC line.
I don't think that was for pain control, was it?
So I'm not sure how much influence that had on the judge, but if it had any influence at all, I would suspect that it probably didn't help the claimant's cause.
Yeah, under the influence isn't really a place to be for him.
No. Lastly, the documents that I think really helped us out in this case, especially, were the statements that we were able to obtain from the employer. The employer's procedures here, upon learning of a work injury, were to immediately investigate and to obtain written statements from anybody who might be involved. And in this case, they had to reach out to their client, which is always a little bit dicey for an employer because you're dragging essentially a company from whom you want business, you're dragging them into a claim essentially against them for an injury that happened there. Now, I don't believe that Custom Er would have ever faced any liability in this, likely as a result of the contract between our client, We Pick 'em, and Custom Er to indemnify them, defend and indemnify them for any injuries that occurred at Custom Er. You still, I mean, one of the challenges that we had in this case was that we had the two employees from Custom Er, the safety coordinator and the on-site supervisor, and as it turned out, only one of those individuals was present for trial. because it would have been highly inconvenient for customer to have both of those individuals away from the job site for testimony at the workers' comp board. Although you brought up an interesting point earlier about that.
Well, with the transition to virtual hearings, you could essentially still have one or both of those witnesses still on site for work and only really have to step out for their testimony, which I'm not sure if that would really obviate the need for the written statements, given the fact that they're taken much closer in time to discovering the incident and your investigation into that than your testimony several months later.
That's an excellent point. So another, I think, very compelling thing about a statement taken as contemporaneously with the accident as possible is that witnesses' memories tend to be fresher, closer in time to the incident than they are as you become more remote. And that just makes sense.
And we've all seen claimants' descriptions of the injury and accident change, and witnesses on both sides are no different.
It happens for definitely, and that brings up a third reason, really, why getting those statements is very important. At least it was in this case, is that it tends to make the description of what happened more consistent. If you have documents that are prepared contemporaneously with events, and a witness uses that document to refresh their recollection before testimony, they tend to testify more consistently with the document that they prepared contemporaneously with the accident. So the documents in this case really helped, I believe. They were part of the difference. Again, we're noticing the difference. We believe that they were part of the difference and what helped us prevail on this. The second practice pointer that I would like you to take away from today's presentation and our case study is the idea of preemptive prejudice. Now, we talked about how late notice by a claimant can be excused if there is no prejudice to the employer as a result. And what happened under the statute and the case law is that once the employer demonstrates that written notice was not provided within 30 days of the accident or death, then it is incumbent, the burden of proof shifts to the claimant, and it is incumbent upon the claimant to demonstrate that there was no prejudice to the employer. What we advocate is that you preemptively demonstrate that there was prejudice. Don't leave it up to the judge. Don't leave it up to the claimant to show that there was no prejudice to you. Proactively, preemptively demonstrate the prejudice to you as a result of the late notice. Now, in this case, we had a couple of good pieces of evidence in connection with showing preemptively the prejudice to our client. The first was that customer had on-site facilities to treat individuals who sustained work-related injuries. And one of the focuses in the case law for demonstrating prejudice to the employer is the inability to provide the employee with prompt medical care. So the fact that the claimant didn't give timely notice in this case prevented customer and the employer from getting him treated right then and there on the job site. The second thing that allowed us to demonstrate prejudice to We Pick'em in this claim was that We Pick'em had that very well-defined protocol following an injury as described in the employee handbook that the claimant acknowledged receiving. And that protocol included performing a prompt investigation, again, providing the employee with medical attention immediately. This employer has a contract with an occupational health clinic. And so, depending upon the location of where the employee is injured, they have a clinic standing by, ready to evaluate and treat and provide first aid to a claimant. And as we discussed, that is among the top concerns of the board panel in determining whether or not there was prejudice to the employer, the ability to provide prompt medical care. And then lastly, although this issue is currently in some flux because of a recent federal ruling with regard to OSHA standards and drug testing, this particular employer had a protocol where they drug tested every employee who has a work-related injury. Some employers are moving away from doing automatic drug testing as a result of some concerns under the OSHA regulations. So this was what we did to prove preemptive prejudice in connection with this claim. Have you ever seen or used yourself preemptive prejudice as a tool in showing the difference or making a difference in a notice claim?
As a matter of fact, I did.
How did I know that?
It's almost like you're my boss. Now, I had about a month and a half ago a notice issue come up in a case where it was for a delivery company, and the delivery company employee picked up his packages from a customer, and he gave notice to the customer employee who was kind of supervising the area, but never gave it to his employer proper. And so he didn't treat them for 9 months, and then after that, it took a while for everything to get filed with the board, so the employer didn't actually have notice of the claim until 11 months later. And at that point, they tried to obtain the scan logs for the scanners that go with delivering the packages, and because those logs were maintained by the customer, and the data was gone. It wasn't retained for that period of time. And it doesn't take 9 months for some of that data to disappear. I know certain of our other clients have video evidence, video surveillance of their premises and things
security footage, right?
Correct. And loss prevention and things of that nature. And they only retain that footage for 30 days. And there's a lot of factors that go into that, so you can't just easily say, oh, give it a longer window. But if they receive notice within those 30 days, they at least have a chance to try to secure that evidence to show potentially that an incident didn't actually happen. But by delaying and not giving that written notice within the 30 days, you could essentially be hamstringing the employer from defending their claim.
I think that's an excellent demonstration of how you could preemptively show that there was prejudice to your employer in your situation as well. Did you prevail?
We did.
Excellent.
And even again in this case, had there been some sort of video evidence, and even assuming the claimant did actually have an injury, being able to show that video to your doctor, to their doctor, and ask if what you see and the forces that are involved and how quickly the claimant stood up would have or could have resulted in the injuries he's claiming could be invaluable.
Good point. So our second practice pointer that we'd like you to take away on what the difference is in prevailing on notice is to shore up your argument about preemptive prejudice to your employer. Next. Lastly, we advocate for what we're going to call a multi-pronged, there's a big typo in that title, multi-pronged defense approach. If you recall back to our bare bones facts slide when we were just presenting you with the notice argument, the only defense that would be raised based on the failure to provide written notice would be notice itself. But in this claim, we raised every issue that we could fairly raise. And of course, this was the C7 claim, so the defenses were raised on a C7, not on the newer 404 or 304 forms. And ultimately, the arguments that we've zeroed in on and that we presented to the judge at the conclusion of development of the record was a lack of credibility of the claimant, which we were able to demonstrate with the documents that we produced. And so we argued that his lack of credibility should lead to a finding that he fabricated the accident altogether. Secondly, we argued the notice plus prejudice. And again, we believe that it's best to buttress your notice argument with the preemptive prejudice. And then lastly, we also presented the judge with a fraud argument based on the claimant's misrepresentations regarding his previous treatment, which has been found to be by board panels a sufficient basis for finding a material misrepresentation. So what we did was we presented the judge with three, we think, pretty good defenses for why it is that this claim should be disallowed, not only the notice defense. And that, we believe, was the difference here in this case because we presented the judge with a much richer tapestry of what kind of person the claimant was in this case and what lengths he might be willing to go to fabricate that this accident actually occurred as he said it did.
Now, I'm confused. Would the fraud argument prevent the case from being established?
No, that's a good point. Sometimes we raise fraud among the defenses that we're raising, especially if you can in a situation where you're raising notice, because it's usually a he said, she said, he said kind of situation where the claimant will allege that the employer was aware of the injury, and of course our employer will refute that they were ever told about the injury. So if you can raise credibility issues with respect to that what the claimant's evidence is going to be, you're ahead of the game and you're helping to tip the scales, I believe, in your favor. And then secondly, it also provides the judge with a lower hanging fruit. So if the judge is not inclined to disallow your claim on a notice theory, because as Mr. Cousins in our office frequently opines, notice is a disfavored defense at the Workers' Comp Board. And he's right in a sense because it leaves the claimant without any coverage for medical care. So with a fraud, with fraud is one of the options on the menu for our judge. If he found it unpalatable to prevent this individual from getting any treatment whatsoever, because if he disallowed the claim on notice, the claimant wouldn't be able to get treatment either under the private health insurance or through the workers' compensation claim. The judge could find fraud, which would give the claimant treatment he allegedly needed, and also but prevent him from getting any indemnity, assuming that the judge exercised his discretion and permanently disqualified the claimant from benefits. So we offered it in this matter as sort of a low-hanging fruit that we hoped the judge would, at a minimum, give us the fraud finding, but based on what was, we believe the difference in this case, which was a compelling argument of lack of credibility, documentary evidence demonstrating the lack of credibility, which tipped the scales in our favor that notice was not timely provided, the judge felt comfortable in disallowing the claim.
Yeah, because on my case, I had a couple other arguments too, in addition to notice.
What'd you have?
Because as I said, it was a injury where the guy didn't treat for many months, and there was a causal relationship issue too. Because similarly to your case, we went and we obtained the prior medical records, and we saw that there was an X-ray that was the first medical treatment 9 months later, and so I wanted to actually take a look at the films because I'm neurotic. And in this instance,
in a good way, in an endearing way.
Okay. But in this instance, the claimant was claiming a fracture to his kneecap, and my favorite, a fifth metacarpal fracture. And so we were able to get the X-ray studies of both, and in reviewing the X-ray of the hand, I noticed that the fracture had healed, but it hadn't remodeled. And so just for some background, when broken bones heal, it's like they're being stuck together with super glue. I mean, they're together, but they're not just one uniform piece of bone. That happens as a process called remodeling, and over time, the two stuck together pieces just fuse back into one solid piece. And so I noticed on the X-rays that this fracture had healed but hadn't remodeled. And so that puts a time window on how old this could have been. So based on some of my research, it shouldn't have been any older than 6 months, so it definitely shouldn't be the 9 months the claimant was claiming, which also casts further aspersions on the claimant's credibility, as well as prevents an alternate factual basis for the claim to be denied.
So it sounds like in your case, your multi-pronged approach included the late notice, preemptive prejudice as a result of the inability to get evidence that you would have been able to produce had the claim been reported timely, and you had a defensive causal relationship based on the findings that you discovered on the X-ray.
Correct.
And again, did you prevail?
We did, and the fun thing is regarding preemptive prejudice. On appeal, the claimant's attorney tried to argue that, well, it's our burden of proof. We don't have any evidence that there was any prejudice because that's not information that we have, and frankly, we don't believe the testimony of the other employee, and that's not sufficient enough.
No, not when you've made the prejudice argument that you made, which seems like it was the difference.
It was, and especially when you have a pro-claimant judge that bounces a case on notice, then you know that there's got to be something different about it.
Correct. Well, that's pretty much our presentation. I'd just like to recap what we feel are the important practice pointers in this case study, which helped us make the difference on this notice case. It is, please know the importance of documents in defending your claim. In this claim, the witness statements, the prior medicals, the employer procedures, and ultimately documents questioning the claimant's credibility were part of the difference in this claim. Preemptive prejudice, don't wait for a claimant to show that there was no prejudice to you and then refute the lack of prejudice. Go ahead and preemptively demonstrate the prejudice to you as a result. And then lastly, we believe that these things culminated in the difference in this claim, which is the result of a multi-pronged approach. So that is our presentation for today, our case study. And at this time, we'd like to open up the floor to questions from the audience. Please be aware that everyone has been muted during the presentation, and so once we unmute you, if there is a microphone nearby you and your dog is barking or the TV is on, that everybody is going to be able to hear what's going on at your home, which is fine, but it depends on, I guess, what you're doing.
But in the lower left-hand corner, you can mute yourself if that's the case.
That's right. Thanks, Brian, for reminding us of that. So with that being said, do we have any questions from the audience? Man, we must have been fantastic.
You were very thorough.
Either that or everyone's asleep.
I do want to say that the use of your senses art of war there is absolutely brilliant.
Our sense of what?
Senses art of war. Your book.
I wish, I mean, the fortuitousness of finding that book in one of my attorney's offices was fantastic. Wouldn't you agree?
We can't. What can I say? My office is just full of props.
All right, so I guess if nobody has any questions, then we'll wrap up for this week. Najee, you want to? I would just like to remind you that this is a monthly series, and we would invite you to tune into our next episode of On the Bench, starring the LOMAD players, and that next episode will occur on July 27th of 2018 at noon, as usual. We hope to see you all tune in again. Go ahead.
Yeah, you did a pretty good job.
Thanks, everybody. Well, what did you think? I mean, did you think that the fact section was too long?
No, I like the story time.
Yeah?
Very whimsical.
So, have you noticed anything different about me?
New shirt?
No, I got my hair cut.
Oh.
This one.
Yeah, women's haircuts, not really my thing.
Really, Brian? I thought you might notice the difference.
Well, these things happen.